Today we're going to tackle something that can seem super complicated, a civil lawsuit. We're going to break it all down and turn that legal maze into a simple, easy-to-follow roadmap. So, let's get right into it. We've all seen those courtroom dramas on TV, right? The last-minute evidence, the shocking confessions on the stand. But have you ever stopped to wonder how a lawsuit really works, like from the very beginning to the very end? That's what we're unpacking today. All right, so here's the plan for our journey. We'll start with the first moves, then look at the off-ramp to settlement, talk about preparing for trial, dive into the courtroom showdown, and wrap up with the final verdict. Let's kick things off with phase 1. Okay, so every lawsuit has to start somewhere, right? This first part is all about those crucial first steps that get the ball rolling. This is where the paperwork gets filed and that all-important legal clock officially starts ticking. So it really boils down to a quick 1, 2, 3. Step 1, the person who's suing, that's the plaintiff, files an official complaint. Step 2, the court sends out something called a summons, which is basically an official heads-up to the person being sued, the defendant. And step 3, the defendant has to file their own response, what's called a written statement, to tell their side of things. And check this out. There's no time to waste. The court has to get that summons out the door within 30 days. And as soon as the defendant receives it, bam, a new 30-day clock starts for them to get their response in. You see, this isn't just red tape. It's the system's way of making sure things move along and don't just drag on forever. All right, so just because a lawsuit has started doesn't mean it has to go all the way to a big trial. Think of it like a highway. The legal system has built in a few critical off-ramps, giving both sides a chance to settle things early. And what's the quickest off-ramp of all? It's pretty simple, actually. If the defendant just admits they're in the wrong in their written response. If that happens, it's pretty much game over. The court can wrap it all up and issue a judgment right away. But what if there's no admission? Well, the court doesn't just sit back and wait. It actually gets involved. Within just 10 days, the judge will bring both parties in to see if they can find some middle ground, some kind of compromise. The court is actively trying to help them avoid a full-blown trial. Okay, so if those early settlement off-ramps don't work out, we're back on the highway, heading straight for the courtroom. This next stage is all about getting ready for the big showdown. This is where both sides really dig in, gather their evidence, and figure out exactly what they're fighting about. And a huge part of this prep phase is something called discovery and inspection. Now, forget what you've seen on TV, where a lawyer pulls a secret document out of their briefcase for a dramatic gotcha moment. That's not how it works. In real life, the rules say everyone has to put all their cards on the table. Both sides have to share everything, all their documents, all their evidence, no surprises. It's all about making sure the fight is fair and based on the facts. And believe it or not, the pace picks up even more here. The court has only 15 days to frame what are called the issues, which is just a legal way of saying they define the specific questions the trial needs to answer. Stuff like, was the contract actually broken? Then, the second those issues are set, a new 15-day timer starts for both sides to hand over their witness lists. We're talking a real sprint to the trial. And here we are, the main event. All that prep work, all the documents, all those ticking clocks, it's all been leading up to this moment, the trial. This is where each side finally gets their day in court to make their case. The way this plays out is actually pretty logical. Since the person who started the lawsuit has to prove their case, the plaintiff goes first. They lay out all their evidence, call their witnesses, and try to build their argument. Once they're done, it's the defendant's turn to hit back with their own evidence and witnesses. So, after all the witnesses have spoken and all the evidence is in, there's one last chance to score points. It's the final arguments. Both sides get one last shot, within a 15-day window, to connect all the dots for the judge. It's their closing statement, their big chance to say, here's everything we've shown you, and here's why we should win. The closing arguments are done. The evidence is all in. And now, we wait. We've reached the final leg of our journey. This is where the judge takes everything they've seen and heard, goes back to their chambers, and makes the final call. So how long does that take? Well, there's a final deadline for that, too. And it all comes down to the number you see here, 30. The court has at most 30 days to deliver its judgment. And that's super important because it means cases can't just get stuck in limbo forever. The system is designed to push toward a final answer. So there you have it. The judgment is in. Our 11-stage roadmap seems to have reached its destination. But is it really the end of the road? That's the big question. Because even with a verdict, the story might not be over.
There are things like appeals, which can start a whole new chapter. It's a great reminder that in the world of law, the end of one journey is often just the start of the next one.